They hit Elon Musk with a $3.2 million fine, thinking he'd just pay and move on. But what he did in that courtroom left even the judge completely stunned. It was supposed to be a routine morning. Inside courtroom 7B of the federal courthouse in Fresno, California. Rain tapped lightly against the windows. The clerk shuffled papers. Reporters sat bored, adjusting their cameras and sipping coffee from paper cups. Then the door opened, and Elon Musk walked in alone. No security detail, no legal entourage. Just a gray suit, dark tie, and an unreadable expression. People glanced up, curious but not shocked. Musk had been summoned for allegedly violating court protocol during a previous corporate litigation hearing involving one of his companies. According to the court's complaint, he disclosed sealed details from the proceedings during a press event weeks prior. It was a breach of conduct. Clear and simple, or so it seemed. Judge Deirdre Colton presided that morning, sharp, precise, known for her no-nonsense attitude. Especially when it came to high-profile personalities. She looked up from the bench, met Musk's eyes for a brief second, and immediately returned to her notes. Elon Musk, she began, her voice calm but firm. You have been found in violation of federal court orders relating to sealed testimony. The fine is $3.2 million, to be paid within 14 days. There were no gasps, no dramatic pause. This was Elon Musk, after all. Billionaire, CEO, media magnate. A few million. That wouldn't shake him. But something about the way he stood there. Hands loosely folded, no reaction. No objection, caused a subtle shift in the room. Judge Colton leaned forward, perhaps expecting a reaction. Do you understand the terms of the judgment? She asked. I do, Musk replied, his voice level. But I'd like to respond now. Heads turned. A few reporters straightened in their seats. The man hadn't brought a lawyer. And here he was asking to speak for himself. In front of a federal judge. Judge Colton looked skeptical. Mr. Musk. I recommend legal representation before continuing. With respect, Your Honor, he said. I think it's more appropriate that I handle this personally. She gave a slow nod. Proceed. And that's when things began to shift, suddenly. At first, Musk reached into his inside jacket pocket and pulled out a single sheet of paper. It was neatly folded, no binder, no folder. He placed it on the table in front of him. I'm not disputing what I said publicly, he began. But I am disputing whether the gag order applied. In the context it was used. That raised eyebrows, a legal gray area. He continued. The order referenced in the contempt filing was tied to Section 35B of the protective hearing order issued on March 11. But according to subsection 35B, 3. Public safety exceptions permit disclosures under federal fair use exceptions, especially when the disclosed content refers to stockholder impacting risks. Judge Colton blinked once. Reporters began typing. I only mentioned one aspect of a manufacturing process. That, if misunderstood, could have been dangerous for consumer use. I didn't name names, I didn't cite protected documents. I referenced my own concerns. Based on what I saw firsthand, he said. The courtroom grew quiet behind him. A paralegal leaned over to whisper something to a colleague. Even the bailiff, who had been watching the door, looked slightly confused. Judge Colton raised an eyebrow. Are you suggesting that you're protected under federal whistleblower statutes? I'm saying, Musk replied, that the fine being levied against me may contradict precedent set in Stansfield v. Verde. U.S. Tech Holdings, Ninth Circuit, 2004. Where the court ruled that executive disclosures that serve a public interest cannot be penalized under seal protection if the statements fall outside the original parameters of the gag. There was a specific case, a ruling, a dated precedent. It wasn't a flamboyant gesture. It wasn't showmanship. It was strategic, calm, surgical. And now everyone in that room knew it. But Judge Colton didn't like surprises in her courtroom. And Elon Musk had just flipped the script. Judge Colton didn't respond right away. She sat back, fingertips pressed together, staring at the man who had just quoted circuit law. Like he belonged at the counsel's table. For a long moment, the only sound in the courtroom was the buzz of overhead lights and the occasional tap of a reporter's laptop keys. "Elon," she finally said, dropping the formality for the first time. "You realize that referencing precedent in this courtroom doesn't guarantee exemption. This isn't a theoretical argument. This is a federal penalty." Musk didn't flinch. "I'm aware. But it's not theoretical. If the penalty itself ignores its own framework." It wasn't what he said. It was how he said it. Calm, measured, like he had practiced the lines 100 times. But not in front of a mirror. It came from something else, certainty. Not arrogance. Not charm. Just clarity. The courtroom's atmosphere had changed. The judge was no longer speaking at a man accused of misconduct. She was debating someone who might actually know what he was talking about. A reporter near the back whispered, "Why didn't he bring his legal team?" Another leaned over. He must have wanted to make this personal. And maybe he had, because by now, it was personal. "Mr. Musk," Colton said, slipping back into a formal tone. "Are you requesting a formal motion to dismiss the fine?" "No, Your Honor. I'm requesting a reassessment based on Statute 12-87F, Provision 4. I believe the court's penalty exceeds the bounds of what that statute allows. In cases where sealed disclosure is nonspecific and intended to address imminent shareholder concerns." He paused. "And I can provide examples of rulings that echo that logic." Judge Colton exhaled. "You're serious?" "I wouldn't be standing here if I weren't." There was something slightly off-putting about it. Not disrespectful, never that, just unusual. Like watching someone recite rules in a game they weren't expected to understand, let alone win. She motioned for the clerk. "Bring me the transcript from the March 11th hearing. And get the full ruling from Stansfield v. U.S. Tech Holdings on my desk by this afternoon." The clerk stood and disappeared down the hall, leaving a sudden quiet in the room. "Elon," she said again. This time like a parent trying to understand their child's logic. "You do realize what's at stake here? You're not just calling into question a fine. You're challenging the limits of courtroom discretion." He nodded. "Yes. But respectfully, Your Honor. If a court can issue unlimited fines for statements that weren't protected by the actual wording of the gag order, then what's the limit of that discretion? Where does it end?" A man from the Securities and Exchange Commission, sitting behind Musk, scribbled something into a legal pad. Another attorney from a rival firm quietly slid his phone out and started typing under the table. This was no longer a simple contempt hearing. It had become something else. A moment. A pivot. The kind of moment that law students wrote about years later, when a defendant chose not to fight the accusation with lawyers or theatrics, but with logic. Musk walked over to the side table, picked up a printed copy of the March 11th order. Something he apparently brought himself. and handed it to the judge. Pages 3 and 4, he said. Third paragraph. You'll see the exception clause. Colton didn't even look up as she took the paper. Her eyes scanned quickly. Her lips pressing into a line. This court has discretion, she said. But even discretion, Musk replied, has boundaries. No one spoke. Then, slowly, she looked up. Not with anger. Not even annoyance. Just something close to realization. She didn't dismiss the fine. Not yet. But something in her expression suggested. The certainty behind it had cracked. But if Elon had poked a hole in the dam, the real test was still coming. How far would the water go? By the time the courtroom reconvened after lunch, word had spread. Local journalists had already tweeted fragments of Musk's self-representation. National outlets began circling the hallway outside 7B. Filled with camera crews, legal analysts, and people who had never once cared about procedural statutes, suddenly asking, can Elon actually win this? Inside, it was quieter, but not calm. The air carried a strange charge. Like everyone was holding their breath. Waiting for a crack, a stumble. Something to prove he was just another tech guy. Playing pretend in a courtroom. But he didn't stumble. Musk sat at the same plain desk. His hands folded, expression blank. He didn't check his phone. He didn't look around. Just waited. Judge Colton returned. Holding a yellow legal pad covered in notes. She didn't sit right away. I read Stansfield twice, she said. And I reviewed subsection 35B of the gag order. You were right about the exception clause. A slight murmur stirred in the gallery. But she continued, holding up the copy he had handed her. This exception only applies in cases where the disclosure addresses direct threats to consumer safety. Not speculation. Your statements in that press event suggested a potential risk, not a confirmed one. He nodded. That's fair. But the wording doesn't require confirmation. It requires good faith. That's a legal standard. And the court can't punish good faith disclosures that fall within that framework. Even if the concern turns out to be non-lethal or exaggerated. She stared at him. You're walking a tightrope, Mr. Musk. I've walked narrower, he replied. A few chuckles slipped out in the back row. Even Judge Colton allowed herself the faintest smile. But just for a second. I also reviewed your timeline, she said. Returning to the bench. You made your comments 2 hours after the hearing. That timing suggests you may have spoken before receiving the full written order. Are you arguing you didn't have access to the language? Musk shook his head. No. I had access. But the hearing's oral summary was unclear. The clerk emailed the full transcript 6 hours later. And by then, the press already had my statement. The courtroom hushed again. Judge Colton leaned in. So you're telling this court that you accept responsibility for the timing, but not the intent? Exactly. I was trying to alert shareholders to a pattern I believe might pose long-term risk. It wasn't about ego. It wasn't about headlines and the data I referenced wasn't taken from classified documents. It came from our own internal audits. That makes it mine, a young lawyer in the gallery whispered to her colleague. He's pulling apart every thread, her colleague whispered back. Yeah, and somehow it's holding. Colton flipped through her notes again, then looked up. You know, she said, this court isn't in the habit of being corrected by civilians. Musk replied without hesitation, then maybe the habit needs review. There. It was bold, direct, but not smug. The tone didn't come from someone who wanted to win an argument. It came from someone who believed the truth mattered more than who said it. For a few seconds, the courtroom was still. Not frozen, just still. Like everyone had been knocked slightly off balance but didn't want to admit it. The judge spoke again, slower this time. You're forcing this court to consider precedent it hasn't had to apply in over a decade. I'm only asking the court to apply its own rules, he said. Colton tapped her pen against the desk. Once. Twice. I'll take this under advisement. We'll reconvene in 24 hours for a final ruling. Until then, no further statements to the media. Understood? Understood. She stood, grabbed her files, and walked out without another word. Elon stayed seated for a moment longer, then calmly gathered his papers and left the room. Not like a man who'd won. Not like a man who'd lost. Just someone who'd said what needed to be said. But as he stepped into the hallway and saw the wall of reporters waiting, it became clear, this wasn't just a courtroom moment anymore. It was about to become a national conversation. The next morning. The gallery filled before the doors even opened. Reporters were there 2 hours early, holding microphones and power cords like weapons, scanning the parking lot for a glimpse of the man at the center of it all. Some people drove in from neighboring towns just to watch it happen. No seats were left unclaimed. Even Judge Colton's own bailiff had to remind spectators that this was a federal hearing, not a movie. And yet, it was hard not to feel like something unusual was playing out. Musk entered quietly again, dressed nearly identically to the day before. Same suit. Same expression. But something about his presence had changed. He wasn't just a billionaire anymore. He was the guy who came into a courtroom and, by sheer force of logic and restraint, made a federal judge think twice. The attorneys seated behind the prosecution table had multiplied overnight. Now, there were 3, 2 from the original team and a new face from the Office of Special Counsel. That alone spoke volumes. At 10:02 a.m., Judge Colton entered and called the room to order. I've reviewed the materials presented yesterday, she began, and I've conferred with a panel of legal advisors from within the district. That sentence landed with a noticeable weight. Judges didn't do that unless something deeply uncomfortable had surfaced. Elon Musk's actions, she continued, did violate the spirit of courtroom protocol, particularly with regard to preserving confidentiality. However, the penalty initially assigned may have overreached the authority granted by the framework outlined in Section 35(b). A pause. Murmurs, she looked at Musk. Your reading of the exception clause and your reference to Stansfield were accurate. And though this court does not make a habit of overturning its own penalties lightly, the fine will be reduced from $3.2 million to a symbolic $25,000, acknowledging both the violation and the legal argument that tempered it. No one clapped, but a ripple of shock swept across the room. Elon didn't smile. He didn't nod. He just gave a quiet, "Thank you, Your Honor." The judge wasn't finished. I want to make something clear. This court is not granting you a pass because of your wealth or public status. You earned this reconsideration because you came in prepared, respectful, and precise. That doesn't happen often, but it matters. A woman seated behind Musk leaned toward her husband and whispered, "I thought he'd be arrogant. But he's not. He's just different." The judge closed her binder. Court is adjourned. People stood. Reporters rushed for the exit to file their stories. Musk stayed in place for a moment longer, watching the judge leave. Then, he turned, walked past the now silent gallery, and exited through the same door he came in. But outside those walls, the world was already writing its own version of the story. Headlines started appearing within minutes. Elon Musk challenges court fine, walks out with a win. Judge revises ruling after Musk's self-defense shakes the room. One man, no lawyers, and a whole lot of case law. Pundits began debating, was this legal genius? Or just another example of the rich playing by different rules? Did it show that courts were bendable if you're powerful enough? Or that truth can still sway even the most rigid systems? Some believed Musk had staged the whole thing, an orchestrated spectacle to win public sympathy. Others believed the exact opposite, that he had been fully prepared to lose and simply spoke because it felt right. But one thing was undeniable. Everyone had seen it. Not in a headline. Not in a tweet. But in real time. A man stood in a courtroom, challenged the very structure trying to fine him, and changed its mind. Not with money. Not with force. But with words. But as the noise outside grew louder, the real storm hadn't even started yet. Because now, the public had questions the system wasn't ready to answer. That same afternoon, Judge Deirdre Colton sat in her chambers alone with a cup of coffee gone cold and a legal pad filled with annotations she'd never expected to make. Her clerk had stepped out. Her phone buzzed with missed calls from law school friends and reporters she hadn't spoken to in years. She stared at the door for a long moment before turning back to the notepad. There, in her own handwriting, were 5 underlined words. He wasn't wrong. Not entirely. Colton wasn't new to controversy. In her 26 years on the bench, she'd handled racketeering cases, class actions against pharmaceutical giants, and civil rights disputes that drew national attention. But she'd never encountered someone like Musk. Someone who walked into her courtroom, spoke plainly, and dismantled a multi-million-dollar penalty using little more than footnotes in federal precedent. And what gnawed at her wasn't that she had to reduce the fine. It was that he forced her to admit the court had possibly overreached. She pulled up the ruling again. Section 35B Exception Clause. Whistleblower intent. There it was, clean, unambiguous. Buried on page 4, exactly where he said it would be. She scribbled in the margin, "We missed this." Why? A knock at the door interrupted her thoughts. Her clerk returned with a small folder. "Judge," he said, "the Office of Legal Oversight called. They want a brief on the Musk adjustment by Friday. And Channel 12 is asking for a statement." She waved the second part off immediately. "No press." He lingered. "There's more. Law students from UC Davis are circulating the transcript. Professors are assigning it for legal ethics discussions. It's turning into a thing." She raised an eyebrow. "A thing?" He nodded, hesitant. "They're calling it the Fresno defense. Like when a defendant flips a courtroom using the system's own tools." Colton almost laughed but didn't. "Close the door," she said quietly as it clicked shut. She stared at her screen. On it was the raw transcript of yesterday's session. Elon's words, calm, logical, and strategically placed, stood out like highlighted lines in a textbook. She scrolled again, stopping on one part. If a court can issue unlimited fines for statements that weren't protected by the actual wording of the gag order, then what's the limit of that discretion? Where does it end? That one stuck. Because it was a question that had no easy answer. And every judge in the country would be thinking about it now. Across town, Musk sat quietly in the back of a small cafe off Ashland Avenue, staring out the window while his assistant spoke quietly into a phone nearby. He wasn't celebrating. He wasn't giving interviews. He was just thinking. A woman in her late 50s approached the table, holding a to-go cup. "Excuse me, sir," she said gently. "I just wanted to say, I don't know if I agree with everything you said in there, but I watched it online. And it mattered. The way you handled yourself, it mattered." He looked up, surprised. "Thank you," he replied simply. She smiled, nodded once, and walked away. There was no applause. No fanfare. Just a small moment, a quiet one. Back at the courthouse, Colton reopened a private memo from the district's legal review board. The last paragraph said it clearly. While the reduction in penalty was unexpected, it reflects the court's capacity to acknowledge its own limitations in the presence of well-founded legal arguments. This is not a mark of weakness, but a reinforcement of judicial integrity. She stared at that sentence for a while. Then, for the first time all day, she allowed herself to breathe a little easier. But if a single courtroom could be shaken like that, what would happen when the broader legal system started paying attention? By the next morning, it wasn't just legal circles or headline writers buzzing, it was everyday people. Uber drivers talked about it between pickups. Barber shops in Fresno and Bakersfield tossed around terms like gag order and whistleblower clause as if they were recapping a playoff game. On a late-night AM station out of Modesto, a caller said, "I don't even like the guy. But what he did in that courtroom. That was something else." Cable news shows scrambled to book constitutional experts. Clips of Musk's courtroom appearance started trending, not because he was theatrical, but because he wasn't. There was no table slam. No outburst. Just a man calmly dismantling a fine he felt was unjust. And somehow, that was more captivating than any scripted drama. One segment on a national morning show ran a side-by-side comparison, Elon's transcript versus Judge Colton's revised ruling. A former federal prosecutor shook his head on live television. He played the long game. He anticipated the counterarguments before they even arrived. The phrase Fresno defense began to show up in opinion columns. Editorial boards started asking hard questions. How often did courts issue fines without fully acknowledging legal exception clauses? How many people had simply paid because they didn't have the time, the resources, or the nerve to stand there and push back? Suddenly, Musk wasn't just a billionaire. He was a symbol of something people didn't even know they wanted, proof that the system could still be challenged. And sometimes bent, if you knew it well enough. But of course, not everyone saw it that way. At the Department of Justice, an internal memo circulated, warning federal judges about the precedent this might set. While Musk's conduct was non-traditional, his arguments, if not rebutted, could lead to more courtroom disruptions by high-profile figures choosing to self-represent. A columnist in a San Francisco paper called it dangerous. "We cannot afford to glamorize courtroom gotchas, not even when the person delivering them has a net worth with 12 zeros. The law isn't a game." But others pushed back. A retired judge from Sacramento penned a thoughtful op-ed. Elon Musk didn't challenge the law. He used it. He reminded the public and the judiciary that no system is too powerful to be questioned. That's not rebellion. That's democracy functioning exactly as it should. Even some skeptics couldn't ignore what happened. At a downtown Los Angeles law school, Professor Joanna Menendez opened her civil procedure class by putting Musk's transcript on the board. Like him or not, she told her students, this is how you speak when you've read every line twice. This is how you walk into a room where the odds are stacked and say, here's what you missed. Back in Fresno, Elon remained quiet. No press tour. No public statement. He returned to work, business as usual. But his staff noticed a change in how people greeted him at meetings, more curious glances, more careful tones. One engineer from one of his subsidiaries asked, "Were you nervous in there?" Musk answered, "Yes." "Did it show?" "I don't think it mattered. Because the truth is, the fear never stopped him from standing up and speaking. He didn't override the court. He didn't win by loophole. He followed the rules, he just read them more carefully than anyone expected him to. And that's what lingered. Not the money. Not the cameras. But the idea that maybe, just maybe, knowing the rules could be as powerful as breaking them. But while Elon moved on, the system he challenged couldn't shake the moment. And its ripple had only just started to reach the surface. Weeks later, long after the headlines died down, and the cameras moved on to newer, shinier controversies, the story still hung around, quiet but persistent. In offices and courtrooms across the country, judges mentioned the case in passing. Law firms updated training modules. Professors still slid Musk's arguments into PowerPoint slides titled, "When the Defendant Pushes Back." But the biggest impact wasn't in institutions. It was in people. Marcus Albright, a 34-year-old mechanic from Flagstaff, had never followed a courtroom story before. But he found a clip from the hearing on YouTube. 6 minutes of Elon Musk talking, with nothing but a piece of paper in front of him. No smugness. No shouting. Just a guy making a point no one could ignore. Marcus didn't care much for billionaires. But he watched that clip twice. Then he printed it and brought it into work. "Why would you print it?" his coworker asked. "Because if a man like that can walk into a courtroom and tell the truth without hiding behind 30 lawyers, maybe I can speak up at my next union meeting without second-guessing every word." In Sacramento, a 62-year-old retiree named Barbara Levis filed a motion to revisit an old fine from a housing code violation she felt was mishandled. She brought up the Musk case to the judge. The court clerk, to her surprise, had heard of it. Her appeal wasn't overturned, but it was reviewed again. She got a partial refund. The message wasn't that Elon Musk had outsmarted the system. It was that the system, when confronted with reason and calm defiance, could still pause, reevaluate, and admit error. That's what stuck. Inside the courtroom, Judge Deirdre Colton's decision had nothing to do with admiration. It wasn't personal, it was structural. The facts stood. The argument made sense. And once she saw it clearly, she did what her position demanded. She corrected the course. But outside the courtroom, it didn't feel procedural. It felt like something else. A moment where accountability stopped being a one-way street. In a podcast weeks later, a host posed the question bluntly. Was this about power or precision? Her guest, a legal analyst, paused before answering. Precision is power, it's just quieter. That's what made this so effective. Musk didn't raise his voice, he raised the bar. And maybe that was the lesson. We're used to thinking influence comes with noise, with drama, with spectacle. But this story showed something else. That it's still possible to challenge authority with a straight back, clear words, and the law in your hand. It reminded people, no matter their background, that knowing your ground is sometimes more valuable than any title or name behind you. Because when you're right, and you know why you're right, even a federal courtroom has to listen. At the end of the day, Elon didn't walk out a hero. He didn't walk out a villain, either. He walked out as a man who knew what the rules said. And made sure everyone else knew too. And in a time where noise often drowns out truth, maybe that's exactly the kind of quiet power we need more of. So here's the takeaway. Don't assume every system is immovable. Don't back down just because the room feels bigger than you. Read every line. Know what you're standing on. And speak. Because even the sharpest voices in the room can be silenced by one person with the right words. And the courage to use them. If this story moved you, made you think, or reminded you that logic still matters, then don't forget to subscribe to 30 Minds. More powerful stories are on the way. Stories that will challenge, inspire, and stay with you long after the screen fades to black. Hit the subscribe button and press the bell icon so you never miss an update.